Abortion. It's quite a big topic to talk about in terms of its importance. But when did this become so big of a deal? Well, it all started with this one court case, Roe v. Wade, in 1973. So, let's dig into it, shall we? It all began in 1970 in the Northern District of Texas, when Jane Roe, which was the pseudonym of the case's plaintiff named McCovey, filed a lawsuit against Henry Wade, a district attorney of Dallas County where Roe lived. Jane Roe was an unmarried pregnant woman who had grown up in a difficult environment and challenged the abortion laws of Texas, representing herself and others. Those were the people who could not afford financially to travel to another states or countries where abortion is legal or pay a large fee to the doctors to perform abortion secretly. At the time, illegality of abortion depended on the states, and in Texas, it was illegal unless to save a mother's life. 1970 was also the year which in many places abortion became legalized. This case was instituted by Roe along with Texas attorneys Linda Coffey and Sarah Whittington. After Texas District Court declared its will to continue its abortion ban in June 1970, the case was appealed in the U.S. Supreme Court. Let's have a look at the session of Texas. A session simply meaning what did the state say about this broad topic? The main argument of the states was that they believed strongly in the protection of lives of its citizens, including prenatals. In the 14th Amendment of the Constitution, which can be summarized as all persons born in the U.S. have the right to life, liberty, property, and equal protection, you may see there's the word person, which according to Texas includes fetus as well. The Constitution especially had a significant impact on the U.S. laws. They claimed that the protection of babies' lives from the period of conception was the interest of the state. On the other hand, Roe on her side claimed her rights of abortion, also using the Constitution, but with different perspectives. She highlighted the word liberty from the 14th Amendment, claiming the absolute right to an abortion. The laws of Texas also declares the human rights of marital, familial, and sexual privacy, which was guaranteed by the Bill of Rights. The justices acknowledged both opinions and agreed that abortion was indeed significantly related to the personal rights of privacy, and they understood the risks such as physical and mental health, financial burdens, and social stigma, which can all occur when continuing a pregnancy. However, when it came to the state's claim of the definition of a person, they were doubtful of the wording person. For the reason that the case of Roe v. Wade included the fetus, the case naturally linked to the whole concept of the start of a life. In Jewish, life was believed to start at birth, meanwhile in Catholic faith, life was considered to start at conception. After consideration of past cases involving unborn children, the court concluded saying that the unborn child, including the conception, have never been recognized in the law as a person. Nonetheless, the court also agreed that the Constitution do not cover the right to an abortion completely, which ables individual state regulating rules on abortion. At last, court created a framework for both sides of opinions. In the first trimester of pregnancy, roughly about 3 months, a state cannot regulate abortion beyond requiring that the procedure be performed by a licensed doctor in medically safe conditions. During the second trimester, 4, 5, 6 months, a state may regulate abortion if the regulations are related to the health of the pregnant person. During the third trimester, a state may prohibit abortions unless an abortion is necessary to save the life or health of the mothers, as at this point, states' interest in protecting human rights outweighs the right of privacy. So, was the case of Roe seen so significant to the public? Surprisingly, no. During and after the case, there wasn't much of a reaction from the public, but as decades passed, the case became viewed with more attention, which triggered a movement of anti-abortion communities. However, on June 24, 2022, the case was overturned when the U.S. court ruled that the Constitution do not confer the right to an abortion. Decisions from Roe v. Wade, which was held for more than 50 years, are now overturned, which meant that the states are dependent for their individual laws towards protecting or restricting abortions. Really meaning that now states can do whatever they want without U.S. laws stopping or restricting them. By far, 13 states have already banned abortion, along with the overturn
including Kentucky, Louisiana, Mississippi, and more. Nonetheless, the number of abortions do not seem to decrease or rather increase in a restricted environment. With the overturn of the case Roe v. Wade, the abortion restrictions turned similar to years before 1973, where each states make their own decisions and make things much complicated and difficult.